Okay, the Illinois State Constitution. Section 9, bail and habeas corpus. All persons shall be bailable by sufficient sureties except for the following offenses where the proof is evident or the presumption great. Capital offenses, offenses for which a sentence of life imprisonment may be imposed as a consequence of conviction, and felony offenses for which a sentence of imprisonment without conditional or revocable release shall be imposed by law as a consequence of conviction when the court, after a hearing, determines that release of the offender would pose a real and present threat to the physical safety of any person. The privilege of the writ of habeas corpus shall not be suspended except in cases of rebellion or invasion when the public safety may require it. Any cost accruing to a unit of local government as a result of the denial of bail pursuant to the 1986 amendment to this section shall be reimbursed by the state to the local unit of local government. Oh my God, it didn't say, oh, you have to keep the man or the woman out so that they can support their spouse or children or try to be a responsible citizen. That must be in your Nazi or satanic rules. But anyways, that's this. I'm reading straight like what you wrote. Yeah, we the people. Bail. The Illinois Constitution guarantee of bail is somewhat similar to the U.S. Constitution's 8th Amendment, which prohibits excessive bail and applies to the states through the 14th Amendment. The Illinois Supreme Court held that only crimes for which death is a possible penalty are capital offenses for purposes of the section. At present, Illinois law allows death to be imposed only for unusual heinous murders. Because of this, a constitutional amendment approved by the voters in 1982 and another in 1986 allowed courts to deny bail to defendants accused of other violent crimes. The requirement that proof of guilt must be evident or the presumption great was kept. The Illinois Supreme Court had already held that courts may deny bail in other cases if necessary to prevent the defendant from interfering with witnesses or jurors or carrying out threats. Habeas corpus. Habeas corpus is the right to have a court order for the release of a person who is being illegally detained. The U.S. Constitution contains a guarantee similar to the sections, but the few cases on the question say that it does not apply to the states. But you must remember that the United States Constitution rules over the states' constitutions. Section 10, self-incrimination and double jeopardy. No person shall be compelled in a criminal case to give evidence against himself, nor be twice put in jeopardy for the same offense. This section mirrors two provisions in the U.S. Constitution's 5th Amendment, both of which apply to states through the 14th Amendment. Self-incrimination. The privilege against self-incrimination applies in any governmental proceedings, criminal or civil, judicial or quasi-judicial, in which a person must be compelled to testify in incriminating facts. How can something be quasi-judicial unless you went with the satanic Nazis? Something to consider there. But the privilege applies only if the testimony might bring criminal liability, not if it can have only lesser effects, such as loss of a government job. Under federal decisions, the privilege does not extend to the taking of non-testimonial evidence, such as fingerprints, handwriting samples, or hair or blood samples. Oh my God. You're talking about DNA. The privilege includes the right not to testify at one's trial, and a prosecutor or judge may not adversely comment on a defendant's failure to testify. The Illinois Supreme Court in 1994 held that the guarantee against self-incrimination was violated when police who had a suspect in custody falsely told a lawyer who was hired by his family to represent him and had gone to the police station looking for him that they were not holding him and failed to tell the suspect that a lawyer wanted to talk with him. Thus, the court said any statements the suspect made after the lawyer arrived at the police station should have been excluded from evidence. This 4-3 decision by the Illinois Supreme Court meant that as to such facts, this section offers more protection to suspects than the U.S. Constitution's 5th Amendment guarantee against compelled self-incrimination because a 1986 United States Supreme Court case had held that similar police conduct did not violate the 5th Amendment. Unless it was all a setup at that police station. So anyways, toodaloo, have a great day. Happy Daffodil Sunday.